Yes, ready for dictation. 3, 2, 1, start. Negligence is the breach of a duty caused by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. Full stop. The definition of negligence as given in Law of Torts, Ratan Lal and Dheeraj Lal bracket start, edited by Justice G.P. Singh bracket close, referred to herein above, holds good. Full stop. Negligence becomes actionable on account of injury resulting from the act or omission amounting to negligence attributable to the person sued. Full stop. The essential components of negligence are three: duty, breach, and resulting damage. Full stop. Para. Negligence in the context of the medical profession necessarily calls for a treatment with a difference. Full stop. To infer rashness or negligence on the part of a professional, in particular a doctor, additional considerations apply. Full stop. A case of occupational negligence is different from one of professional negligence. Full stop. A simple lack of care, an error of judgment, or an accident is not proof of negligence on the part of a medical professional. Full stop. So long as a doctor follows a practice acceptable to the medical profession of that day, he cannot be held liable for negligence merely because a better alternative course or method of treatment was also available, or simply because a more skilled doctor would not have chosen to follow or resort to that practice or procedure which the accused followed. Full stop. When it comes to the failure of taking precautions, what has to be seen is whether those precautions were taken which the ordinary experience of men has found to be sufficient. A failure to use special or extraordinary precautions which might have prevented the particular happening cannot be the standard for judging the alleged negligence. Full stop. So also the standard of care while assessing the practice as adopted is judged in the light of knowledge available at the time of incident and not at the date of trial. Full stop. Similarly, when the charge of negligence arises out of failure to use some particular equipment, the charge would fail if the equipment was not generally available at that particular time bracket start, that is the time of the incident bracket close, at which it is suggested it should have been used. Full stop. Para. The plaintiffs have not alleged that the lady surgeon who performed the sterilization operation was not competent to perform the surgery and yet ventured into doing it. Full stop. It is neither the case of the plaintiffs nor has any finding been arrived at by any of the courts below that the lady surgeon was negligent in performing the surgery. Full stop. Over.